Welcome to the virtual lunch. Today is Friday, October 8th, and this is virtual lunch number 408. Our guest today is Noris Ismail, a managing director with Breakwater Solutions, and this is part of our continuing series on deconstructing data risk supported by Breakwater. Hi, Noris. How you doing?
Hi, Ari. I'm very good.
It's great to see you. Tell us about your background and your role at Breakwater.
I would say I consider myself a global citizen, partly because I spent extensive experience in Asia for the past 15 years as my work experience, usually involved in litigation and as well as corporate conveyancing IP technology at that side of the world. And then I moved to the UK 15 years ago and have been focusing on data privacy, data governance, cybersecurity, and as well as issues that deals with emerging technologies. Been involved with around almost 180 plus global data privacy projects, predominantly implementation and using technology to operationalize the client environment, and as well as engage with regulators, stakeholders, data-driven organizations. And it's exciting times ahead because this is a very, very evolving area. In Breakwater, I am leading the global data privacy consulting practice. This is something very, very interesting and timely because there are lots of development in the EU and as well as in the US, as you guys are fully aware. And of course, China, India, the big jurisdictions, the big markets. And this is where I come in to really help to facilitate some of the issues and challenges that clients have more from the operationalization perspective. I would say that for the past 2 years now, we've seen data protection and cybersecurity issues packaged together, especially in the EU and partly in the US as well. There are lots of unreported data breaches, partly because lots of employees shifted their working model to working from home environment. And some of these issues were not well prepared in advance, except for international organization, and as well as very much into how exactly they need to stress test their organizational resilience and their home setting, home office resilience. And we're seeing lots of ransomware cases and as well as issues that link to fraud and also as on transaction payment increased. I know there's a little bit of interlink between cybersecurity and data privacy because of the data that actually hacked in the particular platform environment. Another challenge that I've seen a lot, especially whenever we deal with international organizations, whether in the US or the UK or Europe, is that lots of organizations have started to go back to basic, to understand the data language, what exactly the data taxonomy in their own world, in their own sector, and as well as in their own interpretation in the environment. If we take multinational companies, financial services, of course, it's quite regulated. They do have their own data taxonomy and life cycle. When they go back to basic, they realize that some of this interpretation might be different to one to another. If I ask the definition of personal data to procurement team or HR team, I'm not surprised they might have different understanding and a different interpretation because of the taxonomy. Because of that, organization has started to realize that, hey, we need to actually, A, beef up their security and as well as the data environment. And then B, asking the question, is it okay to actually retain this data forever? Is it okay to share or transfer this data? These are the basic questions that we typically ask. In the EU, there's a Data Governance Act, which was actually drafted last year in November. The purpose of this act is just to ensure that organizations really understand how exactly compliance requirements they need to do in order before they really want to commercialize this data set because of the digital economy and digital transfer from the EU to the rest of the world. And the act is not actually enforced yet because there are lots of consultation and as well as interaction, even with the US Department of State and as well as the US Technology Council, which is actually an EU-US joint effort. And then if you look into the US generally, we have seen the data management is quite hybrid. The reason I say it's a patchwork and hybrid is if you bring the California CCPA requirement, okay, it's very much like a mini GDPR, even though it's not 100% like GDPR, because it has its own approach in terms of the enforcement. And now it's called CPRA, which will be enforced in January 2023 in California. Organizations that have used GDPR as a global framework they have started to actually analyze and assess what are the differences between PIPL and GDPR, and what's the differences between PIPL and CPRA, and what exactly the differences between PIPL and other jurisdictions that an organization is operating in. Interestingly, my experience when I deal with organizations in China, there are three areas that are very, I would say, high risk from the perspective of the Chinese landscape. The first is data localization, because there's a data localization requirement in China, which means if you want to transfer Chinese data to the US, you have to seek authorization from the respective authority because of the residency sovereignty requirement in PIPM. The second area, which is very, very interesting and also still a gray area, is the intersection between the security by design, security impact assessment, and the privacy impact assessment in the PIPM. Because on the other hand, you also need to beef up the security requirements before transferring the Chinese data to the rest of the world. Data protection, privacy, and human rights is actually interrelated to one to another, especially in certain EU countries. And in fact, in some of the countries in the EU, they have called out that privacy is actually a fundamental human rights and it's recognized in the state constitution. So that's more from the bigger picture perspective. But if you bring that definition in the context of business, in the context of work environment, so there's element of employment law that you need to take into account when you process the employee's data. And in the UK, for example, we have to actually comply with some of the elements in the UK GDPR and the employment laws as well. And then if you look into the US landscape, it's quite a hybrid and mixture approach, depending upon the policy of a particular organization. The privacy in the work environment, you have to look into three angles. The first is more from the employment policy with the employees. And then second is more about the equipment, the infrastructure that the employee is actually using, like mobile device, laptop, and even the usage of social media platform, assuming that the employer allows to use social media platform as part of daily communications like WhatsApp. In GDPR, there is actually legal ground of processing of personal data. And one of the legal ground of processing is legitimate interest. So typically, employer use legitimate interest on the basis of processing personal data of the employee. For example, payroll, profiling of data, more from the diversity and inclusion angle, because it involves lots of sensitive personal data, because the employer can actually access and really process this data under legitimate interests. But in reality, if you ask me whether this has been consistently applied throughout organization, it depends on the number of employees. It depends on the sector that you are in, where there are many grounds of legal processing: contract, consent, legitimate interest, public interest, and also security as well. Security and surveillance means if, let's say, there is an investigation by the government or law enforcement authorities on a particular employee, so there is an exemption that the employer can actually release the data to the government or the law enforcement authority because of certain public interest. Typically, these are all called out in the policy, the employer or perhaps the organization policy. Okay, you have rights to ask questions about what exactly people are using with your data, because sometimes you never ask, because these organizations or third parties keep on taking your data and you don't know what's the purpose. Sometimes they say, oh, okay, we just want to actually do a follow-up, but actually it's the other way around. So as a consumer, you have the right to ask. Okay, and this is where the CCPA and CPRA actually really has replicated GDPR. Second, which is equally important, is go back to basics. Try to actually socialize and stress test your data dictionary, data taxonomy, and data lifecycle in your environment, because this is actually the potential risk that might trigger from how exactly they manage the data.
Noris Ismail, everybody. Fantastic discussion. Wow, we appreciate it very much. Thanks to you. Thanks to Breakwater for supporting this series of conversations on deconstructing data risk. I hope everyone has a great weekend.